I'll call it.
Good evening, ladies and gentlemen. Welcome to the International Symposium on Health Governance in a Political Landscape. Earlier today, we spent a large part of the day discussing various aspects of health law, society, and political economy, and were witness to a plethora of ideas shared by scholars from across the world. Needless to say, this has already been a rather enriching day. I am now pleased to welcome you to a very special keynote address titled A Tapestry of Influence, weaving the threads of political economy, health, and trade into the global fabric. A very warm welcome to all our distinguished guests, friends from various sectors, cherished colleagues, and respected members of the audience who have joined us today. We are so fortunate to have amongst us today Professor Dr. Chantal Thomas, Vice Dean and Gladys Family Professor of Law, Cornell Law School, United States of America, who will be delivering the keynote address. Welcome. I am also delighted to welcome Professor Dr. Stephen Marks, Dean, Jindal School of Public Health and Human Development, Professor Dr. James Nidumpara, Professor and Head of the Center for Trade and Investment Law, IIFT, and India Chair, WTO Chairs Program, Professor Dr. S.G. Srijit, Professor and Executive Dean, Jindal Global Law School and Executive Director, Center for International Legal Studies, JGU, and Professor Dr. Deepika Jain, Professor, Vice Dean, and Director for Center for Justice, Law and Society, Jindal Global Law School. A very warm welcome to all our speakers today. To begin with, I invite Professor Dr. Stephen Marks, Dean, Jindal School of Public Health and Human Development, Open Jindal Global University, to please share the introductory address.
Good evening, everybody. It's a great honor and pleasure for me to be here. I think my purpose for being here at this stage of the program is because I'm probably the oldest person in the room. But that being said, I think it's a great opportunity for me to share with you the deep impression that I have of two things at this conference so far and that I'm anticipating for the keynote speaker. One is the depth and quality of the presentations, and two is the cleverness of the titles. Nothing is simply a word of saying trade and health. No, you've got elaborate things. And we have the same thing with the title of the presentation tonight. I think it's just wonderful. We're not dealing with politics, we're dealing with political landscape. We're not dealing with influence of political economy and health. No, we're dealing with a tapestry of influences weaving the thread. That's wonderful because the quality of the presentations have so much substance, and yet we can enjoy the quality of the language as well. So with that, I'd like to express on behalf of the Vice Chancellor of the University our warmest welcomes this evening and turn the floor back.
Thank you so much. I now invite Professor Dr. James Nidumpara, Professor and Head of the Center for Trade and Investment Law, IIFT, and India Chair, WTO Chairs Program, to please share the introductory remarks.
Thank you, Surabhi, once again. It is actually an extremely proud moment for all of us to have this keynote address by Chantal Thomas. So, in fact, I had a conversation with Chantal in the morning, and I was actually looking at her own work, and I had the great fortune to actually cite some of her work in my own writing. One is actually something related to balance of payment crisis. So this was an article which Chantal wrote in 2000 in the American, I think, University Law Review. So the good point is that Chantal has actually moved, pretty much from the area of trade law. She has been working in the field of art law. She has been working in the field of indigenous rights, for that matter, in the field of, I think, transnational crimes. And ultimately, she has come back to the field of trade. So she was telling me that we have come a complete circle. We have come to a full circle, for that matter. And I also believe that this is actually the trajectory of international trade law in the recent times. Why is it so? In the late 1990s, we had the WTO law, we had the free trade agreements and others, things like that. But over a period of time, a number of new topics have been added to international trade. So if you open the trade chapter, I mean the trade agreement of any recent trade agreement, we have got modern slavery, we have got a sustainable food system, we have got animal welfare, we have got trade and sustainable development, we have got trade and labor. We have got every possible subject under the sun in a trade agreement. And that actually, so Chantal Thomas' work actually reflects the change in international trade law in the recent times. And that also goes to show that trade is all, really all encompassing at the moment. It not only deals with the pure market access related issues, it deals with every possible subject under the sun. So I think it is a great opportunity to have Chantal Thomas giving the keynote speech today evening. And that is a great opportunity for all the participants, not only from the trade law community, but cutting across discipline to hear and listen to her perspective on some of the very interesting areas of international law, for that matter. Let me also mention a few things about our center, because when we really look at this topic, I initially felt that there is nothing related to international trade or even economic law, for that matter. So are we actually taking part in a conference where trade is not even there in the core, but it is not there even in the periphery, for that matter? Why should we, join an initiative with Deepika Jain Center and Gender Global Law School, where we have very limited involvement on an issue related to trade? But the fact of the matter is that international trade has become so absorbing these days, because trade is not actually a particular vehicle for economic development. Trade also takes into consideration various social values. You talk about gender rights, you take women's rights, you take about labor concerns, for that matter. Number of these kind of concerns, even environmental concerns, are getting into trade. So that is why we need a scholar of reputation and caliber who can really look into these kind of issues in a holistic manner and offer the path for, progressive development. So that is why I think it is a great occasion, I think, that we're getting, Chantal Thomas for this lecture. I would like to thank everyone in the room, especially my colleagues at Center for Trade and Investment Law. They have really worked hard in order to organize this event, especially Riddhesh Rajavanshi, Pranav Naran, Pavanish, many of the people whom I cannot actually name. They have been working really hard for the last, maybe I think 2-3 months, in fact, for organizing this event. And let me also thank, Professor Deepika Jain, my old colleague at Gender Law School. And she has been one of the, I think I would say the spirit behind this particular conference. And extremely thankful to Professor Rajkumar as well, and also to Professor Stephen Mark. So we are all waiting for the lecture, and I hope that we can start soon. Thank you.
Thank you so much, Professor James. I now invite Professor Deepika Jain, Professor, Vice Dean and Director, Center for Justice, Law and Society, to please share the welcome address and introduce Professor Thomas. Thank you.
Good evening. It is our absolute pleasure to host Professor Chantal Thomas and my individual honor to introduce her. Professor Chantal Thomas is the Vice Dean and Radis Family Professor of Law at Cornell Law School, where she also serves as the Director of the Cornell Center for Global Economic Justice and as faculty director for the Clark Initiative for Law and Development in the Middle East and North Africa. Professor Thomas researches and writes in international law, focusing on international law and political economy on the questions of global social justice. She has taught international law as visitor at distinguished institutions, including Columbia University, Harvard University, Stanford University, University of Minnesota, and University of Texas. And also has taught in other institutions, including King's College, London, American University in Cairo, School of Oriental and African Studies, and University of Paris. Professor Thomas holds a PhD in law from University of Cambridge, a JD from Harvard Law School, and a BA in political science from McGill University. She has consulted for United Nations Economic Commission for Africa, the United States Agency for International Development. Professor Thomas also serves on the roster of experts for Binational Panel Dispute Settlement, United States, Canada, Mexico Agreement. Professor Thomas has authored, like my colleague Professor James stated, more than 50 articles and other publications on aspects of international economic law and development, ranging from human rights to economic law. She has 2 book volumes forthcoming. The first one, a monograph with Oxford University Press on international migration, a monograph with Cambridge University Press on law and development. She is also the co-organizer of the Law and Society Association's International Research Collaboration on Gender and Political Economy. And I've had the pleasure to be a part of that initiative, and I've had the opportunity to learn from her. And we are extremely excited to have you here, Professor Thomas. Thank you for making it to India in such short notice. And we can't wait to to hear you on Keynote. Please do take over.
Well, thank you so much for that very warm set of introductions. I cannot tell you what a thrill and what an honor and what a pleasure and privilege it is to be here. It's so wonderful to meet so many new friends, to see old friends after some time, and to be gathered here for such an extraordinary set of conversations. I'm truly so honored to have been invited to make a few remarks to you this evening and to take part in this international symposium on health governance in a political landscape. So I really want to underscore my sincere thanks to the organizers and the hosts of this wonderful program, Professor James Nadumpara, Professor Deepika Jain, Professor Stephen Marks, Professor Srijit, Vice Chancellor Raj Kumar, all of the wonderful associates here at the Center for Justice, Law and Society, the Jindal Global Law School, Jindal Global University, the Center for Trade and Investment Law. It's really stunning and really quite dazzling, the caliber of discussion that we've heard today. And I particularly want to commend you for your vision and your leadership in bringing together such an extraordinary range of interlocutors to dialogue on these urgent and intricate questions of health, law, and political economy. This open-ended dialogic model that you've established, Deepika and Professor James, in your centers and in your conferences and your programs, this is so important. It enables not only analysis across numerous academic fields, but also exchange across various realms of practice, from academia to government to civil society. And this is incredibly valuable and also rather rare. And that's unfortunate, because in the real world, problems don't come nicely sliced and diced into little predefined packages that reflect our degree programs or our office titles. And this was something that was remarked upon, I think, numerous times today in the discussion around the inherent interdisciplinarity of questions of public health. These kinds of problems require interdisciplinary analysis because they are interconnected and multidimensional. And this is my legal realist training speaking, and I'll talk more about critical and realist methods of legal research and writing in my other talk tomorrow morning, I think will be giving. But I've always endorsed first and foremost a law and society approach that emphasizes the central importance of understanding law in its social context, understanding how law interacts with relevant social factors in order to understand what the best legal solution is in its formulation, its interpretation, and its application. And we can see this clearly when we consider the challenges of political economy, health, and trade that have informed our discussions today, where we have to wrestle at once with very high-level questions of principle, but also with questions related to day-to-day operation and implementation, and to try to understand the relationship between these multiple levels. The COVID-19 pandemic showed us more than ever how very interwoven our problems are, at the same time that it exposed how the fabric of international law and policy that is meant to help us devise comprehensive solutions to such problems has been sharply torn asunder in key places. Consider the statistics that so many of us in this room know very well, that in the first year on global vaccine of the pandemic, that global vaccine inequity was so stark and so evident around the world. In the first year of distribution of vaccines, high-income countries achieved vaccination rates of 75 to 80%, low-income countries far under 10%. High-income countries across North America and Europe were hoarding many more vaccine doses than they needed, tying up the global vaccine supply. There were reports of widespread vaccine wastage in high-income countries, with up to 15 million doses reported to be thrown away in the United States between March and September of 2021, while so many millions of others around the world had no access to this cherished medicine. The current model of vaccine distribution was too reliant on financial competition for limited vaccine supplies, resulting in high-income countries getting first access, with low-income countries being forced to rely on voluntary donations. And despite the prevalence of financial competition, the pharmaceutical industry did not develop the vaccines alone, as we heard many times today, but rather with the aid of billions of dollars of public funding, being instrumental in their discovery and development. And yet too often, the companies that held the IP controlled the manufacturing, distribution, and pricing. The process of securing the TRIPS waiver within the World Trade Organization, the WTO, was time-consuming and burdensome. And although vaccines eventually did begin to flow, with the crucial role played by India that has been mentioned and discussed today, as many others noted, so that the majority of the world's peoples have now received at least a single vaccine dose, the time lag was simply unconscionable. So should there be an enforceable right to health within international economic law bodies such as the WTO, one that would counterbalance the strong patent protections that exist in the TRIPS agreement? Here we have to some degree a question of legal form, whether there should be an enforceable right to health. And this to some degree opens up specific questions of rights discourse and the role of rights in advancing justice claims, both nationally and internationally. And I'll say a few things about this, although the question around the right to health in international economic law is one I believe that Professor Bartels will examine further in his lecture tomorrow. But allow me to observe that whether the claim for access to medicines and other components of public health policy take the form of a justiciable right or not is only one of the formal parameters, one of the types of legal form within which the substantive social policy interest in health could be realized. The question of trade in health could be understood as a particularly salient example of a more categorical set of issues that are often called by shorthand trade and or trade linkage, issues that have played a role in trade discourse at least since the onset of the era of strong multilateral and regional trade regimes, beginning with the establishment of the WTO, the North American Free Trade Agreement, and the European Union, and other highly institutionalized trade bodies in the 1990s. So the first thread of the fabric of international law and policy that I want to examine with you today has to do with the epistemic question of the role of non-trade concerns in trade law. It has to do with profound normative contestation around the trade regime's ability to integrate so-called non-trade social policy concerns within the broader framework of trade. And this also has to do, to a very large extent, with the conundrum that one person's social policy is often another person's disguised protectionism. In other words, every time a social policy goal is considered, which intends to do something other than to advance trade liberalization, it must overcome a presumption, literally, and as a matter of law, it must overcome a presumption that it does not constitute a form of unfair trade or of disguised protectionism. When it comes to health, we do have a relatively robust affirmation of social policy. If one considers, for example, the 2001 Doha ministerial decision on TRIPS and public health, which explicitly supported WTO members' right to take measures to protect public health. And India has always been a moral leader in articulating with clarity the ethical case for access to medicine, as well as an industry leader in accessible medicine. So Prime Minister Indira Gandhi, who presided over the adoption of the 1970 Patents Act that our panels were discussing earlier, made the stirring statement that there should be no profiteering from life or death. And as it turned out, the process-only patent system that was in place with the Patents Act also was supported by a robust industrial policy, one that allowed India to develop its leadership position not only on the moral and ethical questions of access to medicine, but become one of the world's largest producers of generic medicines. The formal structure, though, of that decision, the decision on TRIPS and public health, what was granted by it, took on the very familiar contours within the WTO context of permissive rather than mandatory form. That is, what was established was not an affirmative obligation on WTO members, either individually or collectively, to protect health, either as stated explicitly or as an implicit but direct consequence of an affirmation of individual rights to health. Rather, the decision reflected and established flexibility, an exemption granted to member states to depart from the default rules, the fundamental rules of trade, the basic trade disciplines, if they had the will and capacity to do so. And in that way, the decision on TRIPS and public health, not requiring, but only permitting, if already the will and capacity existed to do so on the part of the state in question, the implementation of a particular social policy reflects, as a matter of form, the text, if you like, of social policy in the context of WTO agreements, which is the social clause of Article 20, the General Agreement on Tariffs and Trade, the GATT. And we can contrast this form, this permissive or exceptionalist form, in health, in labor, and environment, sort of other areas of social policy, with, on the other hand, the quite expansive and mandatory framing of intellectual property as another form of social policy that competes with trade. After all, the theory of comparative advantage holds as a central goal of the trading regime the maximization of consumption and the liberalization of trade flows, both of which would be facilitated by lower, arguably, rather than higher levels of intellectual property protection, which grant monopoly protection to right holders. And so the incorporation of intellectual property protection has been by far the most successful linkage project in the trade regime. Far and away, the most robust establishment of non-trade social policy concerns like the protection of property, and in particular, the protection of intellectual property rights. This is why Jagdish Bhagwati, the renowned Columbia University professor and true believer in free trade, bitterly criticized the establishment of the TRIPS agreement. He called it the tangentially related intellectual property rights agreement. He said the TR stood for tangentially related, because he felt that intellectual property had no business being in a trade agreement. It was clearly an effort to hijack the governance structure of the trade regime in order to achieve non-trade concerns. The story of the ascension of TRIPS is, as we know, very much a global political economy story, coming as it did during a period when the international economic order was characterized by a triumphant and ascendant economic neoclassicism, a framework that Quinn Slobodian and others noted was not deregulatory in any way, but rather re-regulatory, that it very much required governance and governmental capacity and regulatory capacity at both the national and international levels. So not a deregulatory or free market project, but a market regulation project in the service of securing the conditions for cross-border trade and investment, calling for expansive protection of market interests and property rights. And this was true not only in the WTO, but as we know, many of the other international economic institutions in structural adjustment reforms and international investment law, new agreements on investment and intellectual property in the trade regime and elsewhere. But note that, so intellectual property, labor, the environment, human rights, public health, these were all forms of social policy that can be seen as forming competing interests to a unidirectional and linear focus simply on liberalization of trade and maximization of consumption, conventionally held to be at the center of the trade regime. And as a legal realist, I have to point out here that the political valence of these various non-trade social policies, who their proponents and detractors are, really vary depending on the issue. And the reason to point this out is not to be contrarian or to be nihilist, as some have charged the project of critical legal analysis, but rather to emphasize that we can rarely rely on categorical questions of form to help us sort through what ultimately are questions of policy and politics. So consider, for example, the contrast between the resistance on the part of many governments to the incorporation of labor and environmental concerns into trade discourse on the one hand, and the support by many of the same governments to the incorporation of public health. So I'm not going to belabor this point, only to observe it in passing. But the question of whether to incorporate labor and environmental protection did constitute among the most classic and contested versions of the social policy question in the trade regime. And in those areas, the efforts by countries of the global north to integrate protections more centrally into the WTO-covered agreements were strongly rebuffed by the broader WTO membership, dating right back to the very first ministerial conference in Singapore in 1996, which clearly delineated that labor rights were to be addressed by the International Labor Organization, not the WTO, and that the former and not the latter was the competent body to set and deal with labor standards. And further affirmed that low wage and labor costs should be considered a form of comparative advantage in trade, and that labor standards should not be used for protectionist purposes to try to counteract the comparative advantage of low wage economies in certain sectors. So my purpose here is not to agree or disagree with the incorporation of labor and environment into trade. I think there are important arguments on both sides, actually, and would be happy to engage in that discussion with anyone here this evening. But rather to ask us as a group collected here this evening, what kinds of criteria we think distinguish various cases for incorporation versus non-incorporation, or linkage versus non-linkage. The clear differences with which intellectual property, labor, environment, and human rights linkage efforts have been received requires, of course, a political economy analysis that shows how the array of both public and private sector interests that are organized for and against particular propositions deeply inform how they are received in policy space, and so it was with TRIPS. Among other things, the TRIPS agreement, as we know, required countries like India to implement robust patent protection regimes no later than 2005. But the conversation on access to medicines was well underway by then. In 2001, at the Doha round, as the experts were remarking earlier, the TRIPS decision represented a stunning achievement. Thank you so much. I think, Deepika, you're hinting I should slow down to allow the interpreter to slow down, take a glass of water. Thank you. That decision for many political opening was created by a particular moment in global political economy, a moment of vulnerability in the global north. Dr. Shantanu mentioned earlier the terror attacks of 2001. There was a widely read op-ed that at the time the US Trade Representative Robert Zoellick published called Trade Not Terror, that intended to frame the Doha round to take into account that the settlement of the trade regime had been unbalanced, and that in order to secure greater stability in the global order, not just the trading order, the concerns of developing countries had to be more directly dealt with. And yet, contemporaneously with that effort and the framing of the Doha round as the development round, the US government, as we know, both as you were mentioning earlier, rapidly moved to break the patent on the antidote to anthrax after a number of terror-related scares in the halls of Congress. But in the midst of the surging global HIV/AIDS epidemic, the same government arrived at the WTO ministerial conference in Doha prepared to argue strenuously that the HIV/AIDS epidemic and other epidemics that were surging, especially in developing countries, should not be understood to meet the requirement for the exception in the TRIPS agreement. And I also happen to be there, so that we're dating ourselves a little bit here, but I happen to be there as well in Doha as civil society representative. I didn't see you there, but it was a lot of people. But yes, the USTR was there. They brought seemingly hundreds of members of the delegation to make that case. And they made it very, 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 very adamantly. It should be noted, and I think this is a very hopeful, that the current US trade representative, I think, has taken a markedly different track. The Biden-Harris administration has distanced itself from the big tech and pharma industries in a way that was not the case. That was not the case in terms of the aggregation of interests in defining the US position during the Doha round. So the current US trade representative, Ambassador Catherine Tai, as you know, has presided over a shift in the US position, for example, on e-commerce, and has indicated a willingness to reconsider the US positions generally on technology and trade. And this has caused much consternation actually in the US business community. So there's a recent story reported in the political press, Politico, that the US Chamber of Commerce representative was expressing frustration with the US's scaling back of its references to digital trade barriers and its very strong endorsement for free flow of data in digital trade disciplines. And the USTR spokesperson said, you know, we've been signaling for quite some time that we're asking a different set of questions. We're not only asking what's in the interest of US business, we're asking how can we balance the right of governments to regulate in the public interest with rules that guard against behavior that harms American economic interests. And so that's a shift of position that's remarkable for the US. It was certainly not the case back in 2001 at the Doha round. And yet, despite the very adamant position of the US, the global hegemon at the time, economically and politically, against an expansive interpretation of the TRIPS agreement, the Doha ministers succeeded in adopting the decision on TRIPS and access to medicines. And that was a stunning victory against sort of aggregated business interests. And even against the overwhelming influence of one of the great powers who was present during the negotiations. And so this leads me to the second thread that I want to consider, which is the effort to support a decolonial voice in international economic law and to achieve sovereign equality in decision-making within international institutions. So in many ways, the decision on TRIPS and public health represented an important victory in that effort, an effort that had arced over many decades since the post-World War II inception of the trade regime. Consider that in its inception, the GATT, as we know, was really no more than a small club. The number of countries and territories that signed the 1947 protocol provisionally adopting the GATT, the precursor to the WTO, numbered just 23. And India was one of them, one of the very few actually representing the global South. And accession to the GATT protocol and provisional application was one of India's first acts as an independent nation in 1947. Already by the 1950s, in what became known as the Haberler Report, the GATT and developing country members within it were pressing for the articulation of a framework that would address the concerns of the smaller economies. Yet it wasn't until the force of massive decolonization in Africa and Asia led newly independent states to begin to organize, not in the GATT, but in an alternate institutional form, the form of the United Nations, particularly within the UN Conference on Trade and Development and the UN General Assembly, that alternate institutional pressure began to result in the GATT taking concrete steps to recognize the issues of developing countries, most notably with the 1971 decision establishing the principle of special and differential treatment, later made permanent the 1979 enabling clause. The most robust articulation of this alternate vision, of course, was not in the GATT at all, but in the UN General Assembly's 1974 declaration on a new international economic order, which emphasized the principles of equity, of sovereign equality, interdependence, common interest, and cooperation among all states as a fundamental shift in the orientation of the global order and the global economic order necessary to correct for centuries of structural, economic, and political subordination of the global South by the global North. And yet, as it became implemented in the trade regime in the form of this decision on differential treatment, again, the form was quite telling. It was, again, the permissive exceptionalist form, the form of a waiver, setting up a contrast between the affirmative trade disciplines on the one hand and the not mandatory but permissive provisions for governments to adopt provisions for developing countries if they so chose, if they had the political will and the capacity to do so. And so there was no obligation, no affirmative obligation to undertake measures to correct for structural inequality between the global North and the global South. And in that way, as a matter of both form and principle, the instruments in the GATT depart from the vision of the new international economic order, which saw all of these principles as affirmative obligations held by all members of the international community equally. So in that way, the GATT institutionally reflected a narrow range of interests, very much in contrast to the expansive terms that a one state, one vote view would have facilitated and did facilitate in the context of the UN General Assembly. And so here we come to questions of institutional form and procedure. That, as we know, the voting structure and dynamic of the GATT WTO, though formally it occurs by consensus, has historically been dominated by a very small group of powerful countries within an inner chamber, both figuratively and sometimes literally, of decision-making that was nicknamed the Green Room. And in that way, the GATT WTO as an international institution has historically skewed dramatically away from a one state, one vote model and towards much more direct reflection of underlying realpolitik that also in differing ways characterize the Bretton Woods institutions as a whole, the IMF and the World Bank and the UN Security Council, where the distribution of the background distribution of power is directly linked to who decides. But when it came to the 2001 decision, to come back to that decision on TRIPS and public health, we saw a more intergovernmentally democratic model that was reflected in one component of the WTO decision-making rules that is explicitly majoritarian, or actually supermajoritarian. The WTO agreement permits a waiver to be adopted if 3/4 of the WTO members agree. And that facilitated countries to band together to ally and to really stand up against the powerful interests that were assembled against the exception, an expansive interpretation of the TRIPS agreement for public health. So that by 2001, the members had grown to upwards of 130. Very different allocation of representation than you had in 1947 with the 23 members and very few from the Global South. Now here we're talking about democratic models of decision-making in international institutions. We have to think about the tension between competing conceptions of democracy, of course. The one state, one vote model under the conventional view of international law doesn't contain any sort of preconditions that the voting states themselves have to be internally democratic. And whether international law at all reflects something like what Thomas Frank called an emerging right to democratic governance is at best hotly contested. But if we examine the background political economy of the TRIPS decision, it's easy to see that in this case, we had an alignment of democratic forces at both the intergovernmental level and at the non-governmental level. That you had a very robust representation by civil society. We heard from a colleague from Médecins Sans Frontières earlier today, Oxfam, so many others were assembled there, as well as non-governmental private sector interests in the Global South, like the generic medicines industry. And the majority of the world states were united, and that allowed for an overwhelming victory for public health and the incorporation of public health as a non-trade social policy concern into the WTO regime. But despite that high water mark for social policy, for democratic decision-making, the aftermath of the TRIPS decision has also been so telling. And again, this was referenced earlier in our discussions. The implementation of the decision and actually the obstacles to implementation have been so telling and have in many ways undermined the victory that that decision represented. So, you know, to begin with, as we know, the decision left for future specifications some important questions of interpretation that didn't get ironed out in 2001. They had to wait until council decisions in 2003 and 2005. And then even there were so many conditions on the export of the use of the compulsory licensing mechanisms and facilities, requirement that you had to produce these medicines. They had to look different from the brand name pills. They had to be a different size and a different color and a different packaging. And just the transaction costs were so high that it was very hard actually to implement the decision. And so the list of countries who actually utilized that decision is very small. If you look at the notifications, who actually used the compulsory licensing decision as a formal matter, very, very, very small number of actors. Now, you could say that despite that fact, that the background terms were altered as a consequence of the decision. And so the phenomenon of what we sometimes call bargaining in the shadow of the law, that assisted the campaign for access to medicines, that the fact that governments could resort to this mechanism, that they had this capability, that gave governments more leverage in negotiating with the pharmaceutical industries to make these medicines more available. And so in that sense, you could say that even if the decision itself didn't get implemented very often, it had a facilitating or enabling effect in terms of the broader effort to achieve access to medicines. But even there, the flexibility that was so hard won in the WTO context, as we know, has been at least partially negated by subsequent preferential trade agreements that contain TRIPS plus provisions, the data exclusivity provisions and the like, that actually make it difficult for generic medicines to be produced. And so this is a way in which the political victory in some ways, it's legislative victory that was achieved in the ministerial conference in 2001 and subsequent decisions has been undermined through the fragmentation of international economic law and the proliferation of alternate venues for trade law and policy. Okay, so Unfortunately, this is not an unfamiliar story when it comes to trade and social policy. I'll give you another example, this time in the area of human rights. Some of you may be familiar with the issue of so-called blood diamonds or conflict diamonds. So this was the issue of the trade in rough diamonds being produced, particularly mined in Central and Southern Africa, allows rebel military groups to use the proceeds from diamond sales to wage extremely violent campaigns, brought suffering to countless numbers of civilians. And so at one point in time, the international trading system said, hey, we should crack down on the trade in blood diamonds and conflict diamonds, and we have the ability to enable the use of trade rules to support governments in their effort to crack down on this trade that is so destructive and so undermining of fundamental human rights. Much fanfare was made of the Kimberley process. It allows for a sort of certificate process where the diamonds have to be certified as having been cleanly produced in a way that doesn't contribute to the conflict diamond problem. But here again, it was permissive, not required, didn't establish an affirmative obligation, simply set up a flexibility for those governments if they so choose to implement it. And the obligation was entirely on the part of governments, particularly the exporting governments, who were governments with weak institutions, low levels of capacity to implement this process. And so as a consequence, it wasn't very long after the apparent victory of the Kimberley process was established that civil society organizations really began to call it out for not being very effective at all. While governments were under these obligations to implement somewhat onerous certification processes with low levels of capacity or support, the massive diamond industry was just floating completely free of the entire process. It had no particular obligations under the Kimberley process. And so the Kimberley process also brings out another component here, which is the responsibility of industry in particular when it comes to this question of trade and social policy. Right? So this is just another aspect of the linkage question, that we need to ask not only which human rights should be respected and reflected in the trade regime, but which bodies, which actors, which entities have the obligations to respect those rights. And so here we have a slowly emerging movement towards what is sometimes called corporate social responsibility, but it remains very attenuated, despite the fact that corporations are literally creatures of public law and policy. They exist as juridical persons. They're created only by and through governments and through law. And they enjoy very robust rights as juridical persons under both domestic and international law. But still, there's only an emerging and attenuated effort to establish duties and obligations that would reflect the massive power that corporations enjoy, both economic and political power that they enjoy in the global economic order. When it comes to the current public health crisis, the COVID crisis, we can say that the international implementation mechanisms have fared somewhat better. But certainly they've been beset by many of the difficulties that we heard today. We have on the positive side, you have the cooperative mechanisms that establish dialogue across the WTO, the WHO, WIPO, the mechanism set up through COVAX, so that by 2024, a majority of the world's population has received at least a single dose of the vaccine. But the delays and rollouts, the hoarding, the way in which a newly salient discourse of national security and trade was used to justify a lack of solidarity have led to stark disparities that only point to other glaring disparities in public health outcomes, both among the rich and poor, in both across and within countries. And throughout all of the controversy around vaccine inequity, the right to health, international law, and the rest of it, the private sector here again is somewhat on the margins of the discourse. And you can see this even in the pandemic treaty, which is currently under negotiation. Where are the direct obligations for corporations, for juridical persons who deploy so much power, influence, and capacity in this area. As with the conflict diamond situation, private industry has issued its own somewhat weak and toothless statement of vision on equitable access in pandemics. And, so that exists as a the level of sort of public relations, while at the same time, private corporations again enjoy a great deal of protection and entitlement created by public law and policy. All of these distortions in the international economic law regime, or arguable distortions or injustices, led to at one point a widely observed exchange between the global justice philosopher Thomas Paugy and the international law professors Robert Howes and Rudy Teitel in a volume on global justice. And I'm simplifying this debate greatly, but the philosopher Paugy denounced the TRIPS agreement for having directly led to the needless suffering and even death of untold victims of diseases that could have been treated by more accessible medicines. So he really indicted the international economic legal order. What was interesting is that Howes and Teitel, while sympathetic to his moral outrage, argued that he had an overly simplistic understanding of how international law works, that the construction of international legal meaning would necessarily reflect as much as it would shape the distributions of political and economic power that underlay those institutions. In other words, Howes and Teitel argued that no matter what structure you put into place, whether you had a right to health or not, for example, the powerful interests would still influence the interpretation and the application of the black letter law. So you had quite a stark difference of opinion. On the one hand, you had the view that change the legal rule and you'll get better outcomes. On the other hand, you had the view that no matter what you do with the black letter law, the powerful interests are going to get their way. So where does the truth lie? Well, we all have our own opinions. I'd love to know what yours are. I have deep respect and admiration for all three of the participants in that debate, but I would share that to me, it seemed as though neither of these views seemed to capture a sufficiently nuanced understanding of the relationship between law and society or law and social change. It's neither the case that you can simply change the rule and expect better outcomes, nor is it the case that you can't expect better outcomes regardless of what change you make to the rule. Rather, discursive and material interests co-constitute each other through law. So we shouldn't be satisfied either with a simplistic structural determinism or with a naive positivism or idealism. Rather, we should see how legal rules and social and political movements that inform them are co-constituting. In that sense, it's not so much that a right to health or another form of health protection would by itself necessarily lead to differential outcomes, but rather, I would submit that the social mobilization that would be required to bring about the negotiation of such a right would help to generate the conditions for the transformation of normative meaning and political will that would allow for its robust application. And so this is why I think the rights movement ultimately is important beyond the legal form. And that's something I think that sometimes the critics of rights talk don't fully gather, is that it's the movement, the mobilization, the political and social mobilization that brings about the legal change that then creates the conditions for a better application, a better outcome of the rule that provides the political will that's necessary for the legal rule to have its intended outcome. The rule by itself is just on paper, right? By itself, it can't obviously lead to a change in outcome, but it's the socially enabling component that is so important. I think it's so important to the linkage effort more generally. So that leads me to my third and final, you'll be relieved to know, thread, which is that we have a need to understand how our legal and political discourses have been created and how they operate so that we can be more ambitious and intentional about shifting them. And here as well, the critical lens is so important. It's important to understand where the gaps, contradictions, and ambiguities are in the Black letter law. and the role of legal and social ideology in compelling outcomes that are not required by the Black letter law. And the goal of exposing and understanding how social practices and discourses of domination and subordination influence legal outcomes. It's not about buttressing ressentiment or reifying victimization or grievance at all. It's a key part of understanding that legal outcomes are not natural or inevitable, such as a more formalistic or scientific view of the law might imply or argue. Rather, understanding the contingency of the law helps us to understand its open-endedness, its possibilities, its susceptibility to change. So, in the context of trade, there are so many, I think, critical lenses that can be applied that can yield this greater discursive and material understanding, and then hopefully open up and create space for a wider range of possible outcomes. And so here, I think tomorrow we'll have some discussions about the TWAIL approach, third world approaches to international laws. Decolonial aspect or the post-colonial perspective is so important. We have to understand, in addition to the decolonial aspirations of the new international economic order, the many ways in which the GATT WTO multilateral trade regime historically entrenched the interests of the global North in ways that were not at all necessarily required by the legal rules. And here, I must recommend to you the essay by your colleague, Professor Chimney, that I was very honored to co-publish along with my co-editor, Joel Trockman, his essay on free trade skepticism and our volume on developing countries in the WTO legal system that lays out in a very clear and systematic, very classically Chimney-esque way, the many ways in which the international trade regime departs from its stated values of open trade and fair play and formal equality. And really, there are some quite massive contradictions in the way that the rules have operated that are clearly evident in the way that trade exceptionalism, for example, benefiting the global North has been treated historically versus trade exceptionalism in the global South. Think of some of the examples I've cited here, the TRIPS decision on TRIPS and public health, the decision on differential more favorable treatment in the 1970s. These were flexibilities that came with a lot of terms, conditions, criteria, extensive criteria. Meanwhile, when the global North decided to go outside the trade regime so that it could protect trade in textile and agriculture, it just did that. So it just created these off-books agreements, just created the multi-fiber agreement, and that there was no need to have an exception or anything like that. That just was just a separate parallel universe that was in place until it was brought into the context of the WTO with the agreement on textiles and clothing. Agriculture we could cite as a similar example. Just one example, right? In the area of international health law, I recommend to you the writing of my colleague Matiangai Sirleaf, who's done really important work resurfacing the path from tropical medicine, as it was called, colonial medicine, to contemporary international health, to illustrate the role of race and racism in the development of the field. She shows how the vestiges of colonial medicine in global health have remained with current efforts to contain infectious diseases. She examines the failure of international law to adequately regulate medical experimentation on historically subordinated groups and the theoretical, legal, and policy implications of coloniality in global health. Her piece is called White Health and International Law. And it's coming out in another edited volume. I'm very privileged to be in the process of publishing now with my co-editors, Kimberly Crenshaw, Justin DeSautel Stein, and Devin Carbato, called Race, Racism, and International Law. And here we're moving beyond a post-colonial analysis, and we are squarely considering the role of race. And that's relatively new and unusual in international law. And we're starting to get more and more scholarship on the questions of racial justice in international law. And this seeming paradox that despite the fact that the very first core human rights treaty was established for the elimination of racial discrimination, the Convention on the Elimination of Racial Discrimination, or the CERD, in 1964, that there has been only a marginal sort of awareness of racial justice issues in the intergovernmental international context. And part of this is just the complexity of what do we mean when we talk about race in international law? How actually would we define the category? If we were to insist on a single analytical category of race, that would simply reenact the anti-scientific, ahistorical ideology of racialization, to see diverse peoples, not to mention individuals, as belonging to some innately uniform set of traits. We don't want to do that. And yet, the indeterminacy of racialized identity can be taken not as a refutation, but rather as a key characteristic of discourses of racialization, the way that they've contributed to entrenching global economic inequality. But this discourse of racialized identity has obscured immeasurable differentiation and contradiction. Rather than evidencing a pre-modern cultural frame, it has provided crucial ideological cover for the formative practices that created the contemporary global economic terrain by permitting the conquest and exploitation of land and labor that shaped today's national and international landscapes. We've also begun to think about the role of gender in trade. And here I've been so privileged to work with Professor Deepika and others in the context of the Law and Society Association International Research Collaborative on gender and trade. And so I'll say just a little bit, because I want to conclude here, about some of our working concepts, beginning with the premise that gender, sex, sexuality, and the family are constitutive of, not peripheral to, global legal orders in their socioeconomic dimensions, that we want to develop and elaborate those insights to articulate how political economy works to produce and reproduce gender roles, not only within households and families, but across other social and legal categories related to sex and sexuality, and to develop those frameworks in a way that is critical, decolonial, and comparative. So we look at unwaged household work as a means of production and reproduction of the labor force. We look at intersections with racial capitalism literature, taking as an understanding that this mode of social reproduction is profoundly marked by race and class. We look at how women and women's work have heavily subsidized industrial capitalism from its inception. And so the goal is to analyze dynamics that keep women's work and classed, raced, and gendered work of social reproduction from being fully integrated into the waged economy, but also to be wary of a conventional response within feminism that would see the means of correcting those inequities simply to attain access to the marketplace as currently configured. So we've got, a lot that we're doing. We're thinking about law and practice, and we're trying to rethink international economic law in many ways from the ground up. We want to challenge the epistemic closure of trade theory and policy through both a new analytics and a new praxis. Analytically, we need a dynamic trade model that can understand the effect of trade not only on consumption and production, but also on employment, not only on aggregate, but also on distributive impact, and not only sectorally, but according to other social categories, such as class, race, and gender. There are promising efforts in this direction currently underway. The US Trade Representative, again, somewhat surprisingly, has been very expansive in calling for distributional analysis of the consequences of trade, and has set up an entire analytical project in the context of the International Trade Commission that we can find on the ITC and USTR websites. But much more remains to be done, and equally as crucially, the formulation of international trade law must be informed by a more participatory politics. So we're in a moment of uncertainty. Such a moment of uncertainty, of indeterminacy, if you like, it could be seen to problematize efforts to define critical analysis internationally, but it may also point the way forward to a more open-ended, a more exploratory, a more dialogic approach to understanding justice and international economic law in its pasts, presents, and its futures. Thank you.
Thank you so much, Professor Thomas, for this extremely insightful lecture. I now request Professor Dr. S.G. Srijit, Professor and Executive Dean, Jindal Global Law School, to please share the concluding remarks.
Good evening, everyone. I'm going to give the concluding remarks. I really do not know whether this is a relegation to the periphery or is it giving me the final word on the proceedings of the day. Had this been a book, concluding remarks would have become the back matter. So with that understanding, let me proceed. It's great pleasure meeting Professor Chantal Thomas here. We met 12 years back in Harvard Law School. You were chairing a panel. You spoke, you waxed vehement and eloquent on the discontentments of globalization. And I spoke about the contentment factor, which could stop an end to the madness of capital mobility. So pleasure to meet you again and look forward to hosting you tomorrow in my law school. We dealt with two monsters, the political and the economical. International law scholars of late have been informing us that political is an inevitability. You have to learn to live with that. And on the other side, economists have made us to believe that economics has been an avalanche and you have to learn to live with that. It has subsumed everything, leaving economists and economic textbooks for us to read or refer to. But the fact is that we live in a world of trade discursivity. Trade has become a rationality. Trade has become a morality. And this inevitability of trade, which is mainly driven by the multilateral trading system, has been beautifully captured by the two-time member of the appellate body, James Backus, using the bicycle theory, that the trade regime will have to move on and on and on and on and on. It cannot afford to stop, because if you stop, the entire regime will collapse. So it's a collective responsibility of the humanity, not just the state. It's the collective responsibility of the humanity to keep the bicycle going on and on and on and on. Where does health fit in this larger scheme of things? Well, health is wealth, health is well-being. However, the pandemic has given us a new understanding that health probably can be the very coexistence of humanity, because when ill health fell upon or befell humanity, we have been taken back to the Eden, from where we have to rediscover our own existence, new meanings, new identities, and truly a new meaning for the self in itself. At that point, I had the chance to read these two novels. One is Plague by Albert Camus, and then Death in Venice. Both speaks about the pandemic blues. But I would say that more than that, they spoke about silently the role of health in larger social production. So that means the site of that social production is, fortunately or unfortunately, the political economy, driven by the rationality, which is that inconsistent with the very spiritual and material idea of trade in its totality. Where do we go from here? Well, we need hope. And it's quite heartening to hear that Professor Chantal Thomas referred about or reminded us about the values of the new international economic order, which gave a new hope to the humanity. But the hope really lies in policy, which is actually the will. The hope lies in law, which has many reality-making possibilities, because law is an extraordinary means for actualizing the dreams and aspirations of humanity. I end on that sanguine note, and I look forward to hosting all of you tomorrow in my law school. Thank you and good night.
Thank you so much, Professor Srijit. May I also request Professor Srijit to please felicitate Professor Dr. Chantal Thomas.
there's a ritual associated with this. And I briefly want to explain to you that the colors represent the different schools of thought, and yellow represents.
Show a picture together.
Thank you, everyone.
I now invite Anmol Diwan, Assistant Professor and Senior Research Associate, Center for Justice, Law and Society, and Ridish Rajvanshi, Senior Research Fellow, Center for Trade and Investment Law, IIFT, to please share the vote of thanks.
Thank you so much, Surbi, and thank you so much, Professor Srijit. And thank you so much, Professor Thomas. On behalf of everyone at CJLS, CTIL, I would like to thank Professor Thomas for that excellent, engaging, and thought-provoking keynote lecture. It has been an absolute pleasure to be able to interact with you in such an intimate setting and discuss such an important topic. Unfortunately, we're out of time, but I hope all our audience members are taking something very valuable with them today. We also had a great turnout today. Therefore, I would like to thank our audience for diligently attending not just this keynote, but also the extensive program we have had throughout the day, including 2 incredible plenaries and thematic sessions. Your participation is a great motivation for us to continue providing a collegial space for knowledge production and knowledge sharing. I would like to take this opportunity to thank our collaborators, Center for Trade and Investment Law, particularly Professor James, the head and professor of CTIL. Without his unwavering support and guidance, this event would not have been possible. I would also like to extend warm gratitude to the team at CTIL. We are grateful for your contribution.
Thanks. Thank you. So before we conclude, I would like to also thank to the team of Center for Justice, Law and Society, CJLS, and General Global Law School for ensuring a successful day 1. My pre-concluding vote of thanks to Professor C. Rajkumar for his continued support for our work, and Professor Stephen P. Marks for his valuable contribution throughout the day today, and Professor Deepika Jain for her excellent guidance and mentorship. Lastly, a big thanks to Indian Institute of Foreign Trade and the WTO Chairs Program, and to all the panelists, chairs, discussants, and the participants and the support staff here at the Indian Habitat Center. On behalf of all of us at the Center for Trade and Investment Law and Center for Justice, Law and Society, thank you so much, Professor Thomas, and everyone. It's been an absolute pleasure. We hope you had a great rest of the day, evening, and please enjoy the drinks.
Thank you to each one of you for joining us this evening. I invite all of you to please join us for dinner and drinks. Have a great night.
Thank you. Thank you so much. Thank you.